This show is part of One Place, a daily network of focused briefings across the stories people follow most.
Welcome to our daily roundup. We are diving into today's top headlines, from federal courtrooms to the halls of the Pentagon, bringing you the essential details on the news shaping our world right now.
A federal judge blocks restrictive Pentagon press access policies.
The DOJ seeks to dismiss Breonna Taylor raid charges.
RFK Jr. overstepped authority on gender-affirming care rules.
Jon Stewart fires back at Elon Musk over propaganda.
Trump struggles to rewrite narratives on major global issues.
Epstein's former attorney denies knowledge of any criminal activity.
Mika Brzezinski reacts to Trump's Pearl Harbor quip today.
Government overreached in transgender healthcare declaration, judge says.
Supreme Court prepares to decide fate of millions of votes.
Trump administration sues Harvard over alleged student protection failures.
Starting with the Pentagon. A federal judge in Washington, D.C. has officially blocked a restrictive press policy implemented by the Trump administration at the Pentagon. This policy essentially threatened journalists with being labeled as security risks if they sought information that wasn't explicitly authorized for public release. The New York Times led the legal challenge, arguing that these changes gave the Defense Department far too much power to freeze out reporters whose coverage they didn't like. The judge agreed that the policy likely violated the First Amendment's protections for free speech and due process, marking a significant win for news-gathering rights.
The policy was approved under Defense Secretary Pete Hegseth back in October 2025, and it created a real exodus of traditional reporters. Out of 56 news outlets in the Pentagon Press Association, only one actually agreed to sign the new acknowledgement. Those who refused had to surrender their press passes, and the Pentagon replaced them with more pro-Trump outlets. While the government argued the policy was necessary for military security, the court found the subjective nature of the rules allowed for viewpoint-based restrictions. This ruling ensures that soliciting information from military personnel remains a protected part of the essential journalistic process.
Now let's shift to the U.S. Department of Justice has made a controversial move by asking a federal judge to dismiss charges against two former police officers involved in the 2020 raid that killed Breonna Taylor. Former Detective Joshua Janes and former Sergeant Kyle Meany were accused of using false information to secure the search warrant for Taylor's home. While they initially faced severe felony counts, a judge previously downgraded those to misdemeanors. Now, the DOJ is arguing that the case should be dismissed entirely with prejudice, meaning it could never be revived. This request comes just 1 week after the 6-year anniversary of Taylor's tragic death.
Breonna Taylor's mother, Tamika Palmer, expressed deep disappointment and called the move utterly disrespectful. She noted that this was the first time she had heard from the DOJ since they took over the case, and she feels they have failed to serve her daughter's memory. The raid itself remains a flashpoint for the Black Lives Matter movement, as officers fired 32 bullets into the apartment after Taylor's boyfriend fired a warning shot at what he thought were intruders. No drugs were ever found on the property. If the judge signs off on this motion, it would effectively end the federal prosecution of these specific officers.
Next up, in Oregon, a federal judge has ruled that Health Secretary Robert F. Kennedy Jr. overstepped his legal authority. Kennedy had issued a 12-page declaration claiming that gender-affirming care for minors was neither safe nor effective and did not meet professional standards. Judge Mustafa Kasubai ruled in favor of 21 states that challenged this, stating that the Department of Health and Human Services violated the rights of states to regulate medical practices. Kennedy's declaration had attempted to supersede existing national standards of care backed by major organizations like the American Medical Association. The court found that the federal government cannot simply dictate medical standards through such declarations.
This ruling provides immediate relief to healthcare providers and families of transgender youth who were facing potential investigations. Alongside the declaration, HHS had referred 13 medical institutions to the Inspector General and proposed rules to block Medicaid reimbursements for transition care. LGBTQ advocacy groups are celebrating the decision, emphasizing that politicians should not be telling doctors how to do their jobs. New York Attorney General Letitia James noted that this win breaks through the noise and provides much-needed clarity. While the government is expected to appeal, for now, the federal government is barred from using this specific declaration to intimidate or punish medical providers.
Moving on to, Jon Stewart is taking aim at Elon Musk after the tech billionaire called him an extremely talented propagandist. On his latest podcast episode, Stewart dismantled Musk's frequent claims about undocumented non-citizens voting in U.S. elections. Stewart pointed out the irony of Musk complaining about election integrity while his own platform's algorithm pushes specific political narratives to millions of users. He argued that Musk has actually had a much larger impact on the warping of American democracy than any alleged voter fraud ever could. Stewart specifically highlighted how Musk has interacted with or tweeted about this specific conspiracy theory over 1,300 times, despite a lack of evidence for widespread non-citizen voting.
The exchange turned into a series of passive-aggressive barbs on the X platform. After Musk called Stewart a propagandist disguised as a truth-teller, Stewart shot back by calling Musk a propagandist without the disguise. Musk seemed to miss the insult, replying that Stewart shouldn't be so humble. Stewart has now invited Musk to appear on his show to discuss their differing views on democracy and self-deprecation. This feud highlights the growing tension between traditional media figures and the billionaire owners of social media platforms, who now wield immense power over public discourse. It remains to be seen if Musk will actually accept the invitation for a real debate.
Now let's look at President Trump has faced a difficult week as he struggles to control the political narrative on several major fronts. His signature style of negotiating through threats and public pressure is running into significant resistance both at home and abroad. For example, Trump recently demanded that NATO partners help secure the Strait of Hormuz, but he was met with silence or outright refusals. This led to a series of bitter responses from the president, where he questioned the usefulness of the NATO alliance once again. Analysts suggest that his usual tactics of threatening tariffs or primary challenges against fellow Republicans are not yielding the same results they once did in his first term.
The resistance isn't just coming from international allies. It's also happening on Capitol Hill regarding voting legislation and the economy. Trump has been lashing out online as he deals with issues like rising gas prices and complex tensions with Iran, which are largely outside of his direct control. His approach of trying to bend opponents to his will is being tested by a political landscape that seems less inclined to fold under pressure. This week has shown that even with the power of the presidency, there are clear limits to what can be achieved through force of personality alone. He is finding it increasingly hard to rationalize these setbacks to his base.
Turning now to Darren Indyke, the longtime personal attorney for Jeffrey Epstein, testified before the House Oversight Committee this week. In a closed-door deposition, Indyke claimed he had no knowledge whatsoever of Epstein's crimes against women and girls. This is a significant statement because Indyke worked for Epstein for over 2 decades and was eventually named a co-executor of his estate. He argued that not a single woman has ever accused him of witnessing or committing abuse. Indyke stated that if he had known about the sex trafficking operation, he would have severed all ties immediately. However, many members of the committee remain skeptical of these claims, given his very close professional and personal relationship with Epstein.
Democratic representatives on the committee have called Indyke a key insider and enabler, arguing that Epstein's operation could not have functioned without his legal services. The committee also questioned him about the existence of hard drives held by Epstein's private investigators, which the House has not yet seen. Indyke's testimony follows a similar line to that of Epstein's former accountant, Richard Kahn, who also denied any awareness of the misconduct. Despite these denials, the Republican-led committee is continuing to dig into the network that allowed Epstein to avoid government scrutiny for so long. The role of these inner circle members remains a central focus of the ongoing congressional investigation into the disgraced financier.
Next, we have Morning Joe host Mika Brzezinski was visibly stunned on air following President Trump's recent comments about Pearl Harbor. During a formal meeting with Japanese Prime Minister Sanae Takaichi, Trump was asked why allies weren't notified before he launched military action against Iran. He responded by saying he wanted the element of surprise, then joked to the Prime Minister, asking why Japan didn't tell the U.S. about Pearl Harbor. Brzezinski held her head in her hands in disbelief, eventually stating that she felt embarrassed for the country. Her co-host, Joe Scarborough, was also left briefly speechless by the exchange, noting that such a comment is unprecedented for a president speaking with a key strategic ally.
The quip was particularly jarring because Prime Minister Takaichi was born 20 years after the end of World War II. While there were some scattered laughs in the Oval Office, the reaction from late-night comics and social media was swift and critical. Critics pointed out that Japan has been a loyal U.S. ally for over 7 decades, and bringing up the 1941 attack during a diplomatic meeting about modern warfare was highly inappropriate. Scarborough noted that this fits a broader pattern of Trump distancing himself from long-standing global relations. At a time when the U.S. needs allies to manage the escalating situation with Iran, these types of comments may further jeopardize essential international partnerships.
Now to Oregon. A federal judge in Portland has ruled that the U.S. government overreached when it issued a declaration labeling gender-affirming treatments as unsafe. Judge Mustafa Kasubai found that Health Secretary Robert F. Kennedy Jr. failed to follow proper administrative procedures before issuing the December declaration. This document had warned doctors they could be excluded from federal programs like Medicare if they provided puberty blockers or hormone therapy to minors. The judge emphasized that the rule of law must be respected in a democratic republic, and the government cannot simply issue declarations to see if they can get away with it. This ruling grants preliminary relief to health professionals who were worried about federal retaliation for providing standard care.
This is actually the second major legal setback for Kennedy and the HHS this week. Just days ago, a judge in Boston blocked several of his vaccine policy changes for similar procedural violations. In the Oregon case, a coalition of 21 states argued that the HHS declaration was both inaccurate and unlawful. The court's decision effectively stops the federal government from using the declaration to coerce providers into stopping these medical services. New York Attorney General Letitia James praised the ruling for bringing clarity to families and patients. It reinforces the idea that federal agencies must adhere to established legal processes when attempting to make sweeping changes to national healthcare standards and provider requirements.
Moving to the Supreme Court is set to hear arguments this Monday in a case that could fundamentally change how millions of mail-in ballots are counted. The case, Watson v. Republican National Committee, challenges a Mississippi law that allows ballots postmarked by Election Day to be counted if they arrive within 5 days. Interestingly, this law was originally passed with bipartisan support and signed by a Republican governor. However, the RNC and the Libertarian Party are now suing, arguing that federal law requires a singular day for elections and that counting late-arriving ballots violates this. They claim that the extra time forces them to spend more money on poll watching and ballot chase programs, which drains their campaign resources.
Mississippi's Secretary of State Michael Watson is defending the law, arguing that states have a constitutional right to govern their own elections. He warned that overturning this rule would invalidate laws in most states and spark nationwide chaos in future federal elections. Election administrators are particularly concerned because requiring all votes to be received and counted on a single day presents massive practical challenges. Legal experts note that what used to be a bipartisan issue of ballot access has quickly become a deeply polarized legal battle. The Supreme Court's decision will have profound ramifications for the next election cycle, potentially disenfranchising voters whose ballots are delayed by the Postal Service through no fault of their own.
Finally, at Harvard, the Trump administration has escalated its legal battle with Harvard University by filing a lawsuit in Boston federal court. The Department of Justice is seeking to recover billions of dollars, alleging that the Ivy League school failed to protect Jewish and Israeli students from campus hostility. The complaint claims that Harvard has been deliberately indifferent to anti-Semitism and has refused to enforce its own rules when the victims are Jewish. This lawsuit is part of a broader campaign by the president to force changes at major universities that he describes as having radical left ideologies. The government argues that this indifference is not accidental, but a form of intentional exclusion that denies students equal access to education.
Harvard has not yet officially responded to the lawsuit, though it has previously announced new steps to address anti-Semitism, including expanded training and updated disciplinary processes. This legal action follows a series of other demands from the White House, including a previous attempt to seek a $1 billion settlement. The administration is also investigating whether the university illegally considered race in its admissions process. Other major institutions like Columbia and UCLA have already faced similar pressure and penalties. The DOJ is citing Title VI of the Civil Rights Act, which bans discrimination in programs receiving federal funding. This case could set a massive precedent for how private universities manage campus speech and student safety under federal law.
That wraps up our briefing for today. Thank you for joining us for this roundup of the day's most critical stories. Be sure to follow us for your next daily update.